Hello everyone, welcome to Community Connection, your window to the world around you. Today, Alan Gershel is in our studio. He is the Attorney Grievance Commissioner for the state of Michigan, who has had a phenomenal career, an amazing history within our Metro Detroit area, and he is going to talk to us today about the Attorney Grievance Commission, his role, and the process in which someone can actually render a grievance with any attorney that we have. That's the wonderful country of the United States that we live in. Mr. Alan Gershel, welcome to Community Connection. It's wonderful to have you here.
Thanks so much.
In the intro, you have had such a rich career. You've done so many different things. You've also worked for the U.S. Attorney for quite a while, for over 30 years.
About 30 years.
Tell us a little bit about your experience there and the process that led you really to the Attorney Grievance Commission.
I began in the U.S. Attorney's Office in 1980 as a brand new baby prosecutor, and I was attracted to public service even before I went to law school. And I had a particular interest in becoming a prosecutor, and I was fortunate enough to be offered a position and spent most of my career doing that in different parts of the office, doing different kinds of cases. I had different management roles within the office, including a couple of times I was appointed as the acting U.S. Attorney when there's a change of administration, and also had a chance to do a special detail in Washington with the Justice Department. So it was a wonderful career. I'm perhaps one of those few people that can say, knowing what you know now, looking back on it, would you have made the same choices? And I can say, without a doubt, I would have.
Probably, yes.
I would have.
Absolutely.
I would have definitely done that.
When were you acting U.S. Attorney? What
time
period was that?
It would have been a changeover between the Bush to Clinton, and then, was it Bush to Clinton? Well, between two change of administrations. Both were Republican to Democrat, and then Democrat to Republican. So it probably illustrates how apolitical I am, because I was appointed in two different changes of administration.
And you also, I believe, worked with the current U.S. Attorney, which is Barbara McQuaid.
We overlapped for a number of years. Ms. McQuaid was actually hired when I was in the U.S. Attorney's Office. I was part of the hiring process that brought her into the office. Perhaps one of the better decisions that we've made over the years, because obviously she's turned out to be a wonderful not only assistant U.S. Attorney, but a great leader of the office and in the community as the U.S. Attorney.
Absolutely. During your tenure there, you have prosecuted some very high-profile cases, one of which comes to mind, and I think many of our audience members will remember this, but you actually prosecuted the chief, William Hart. Talk to us about that and the process that went through.
I had a particular interest in the office in prosecuting public corruption cases. I believe that public corruption was one of those areas that the federal government could perhaps do it in a very special way. We had the investigative tools to do those cases, and also the politics were irrelevant to us. It made no difference, Democrat, Republican. The rule of thumb was you follow the evidence and wherever it leads. And
well, corruption is bipartisan.
It certainly is. It knows no distinction. And corruption cases are difficult to investigate. They're often difficult to prosecute. Often corruption cases take place without any light, so to speak, on it. There are few witnesses to it. And so it was something that attracted me to that kind of work. And eventually I had become head of the what was then called the Public Corruption Unit, and cases involving public officials. That could have been judges, politicians, law enforcement officials, really anyone who was responsible for doing the public business could have fallen into the jurisdiction of my office and that unit.
Now, as chief, he was really convicted of embezzlement.
It was a number of cases. At that time, would have been in the early 1990s, early 1990s. There was an investigation both by the FBI and the U.S. Attorney's Office and by the Wayne County Prosecutor's Office, and we decided that we would combine our resources, because it was thought at the time, with very, very good reason, that we brought the investigative tools, and Wayne County brought the knowledge of local police business, and we combined and we worked together with them on that case. And he was eventually charged and convicted of a number of offenses, including the embezzlement offenses, tax offenses, and was sentenced to prison for a considerable amount of time.
It takes a lot of intensive investigation to put someone of that stature into that kind of situation. What kind of challenges did you face in regarding that? Because in Metro Detroit there has been so many issues and so many issues of corruption. So there's challenges in regards to bringing people to justice. So what kind of challenges did you face?
I think corruption cases are difficult on a number of levels, not least of which is exactly what you point out. When you prosecute a drug dealer, for example, by and large there's not a lot of sympathy in the community. But when you take on public officials,
someone who has been looked at as a leader.
As a leader, has been elected to public office, has perhaps done some very good things for the community. And so it presents some unusual challenges. Plus, at that time, there was, as you recall, there were issues concerning issues of race between the federal government. And at that time, when Coleman Young was the mayor, and there was concerns about whether or not the government was targeting African-American politicians. So that was an issue that was certainly was thought about. But at the end of the day, we held our heads up high because we believed that we were looking at someone who was in a very high position, chief of police,
sure,
committing misconduct. And frankly, I learned a lot from that case by talking to jurors after that case. It's an interesting story I'm happy to share with you if you're interested.
Please, yes.
When the case was over and there was some concerns again about the dynamic of, it was a table of white prosecutors and a black public official. What I believed was a particularly difficult time in this city. And afterwards, I was talking with one of the jurors, and I immediately liked her, and I said, I don't remember her name now, I said, ma'am, can I be honest with you? And I explained to her the concern that we had. And what she said to me, frankly, I'll never forget. She said, what you don't understand, Mr. Gershel, is that most of us don't think that way. That these are officials that are affecting my community, my way of life, and frankly, we applaud the efforts if they're done in the way that apparently was done in this case. So I thought to myself, that was really interesting because here's someone that lives in the community. I didn't live in the community, who was directly impacted by this kind of official misconduct, this kind of behavior. I mean, the police department goes to the very core of a person feeling secure in their community, and yet she felt, it taught me a lesson actually, that things aren't always as clear as they might be made out to be. It's a more complicated issue. So it was a very.
I think people want justice, and
they do
and like
want
you
justice.
Said, they want to feel safe.
Yes, exactly. So that was an important lesson for me also.
Absolutely, and I think directing your focus on that kind of corruption and bringing it down regardless of who the perpetrator is vital. You also were in a high-profile, case regarding judges as well in the 80s. Can you tell us about that?
We had gotten information that there was some degree of judicial corruption both at the 36th District Court, and at that time it was referred to as Recorder's Court.
Right.
And that judges were trading their office for favors. At the district court level, there were several, at that time, district court judges who were believed to have, for example, trading their office for, as it concerned, traffic tickets. There was one judge in particular who had literally had gone into various party stores around the city and was trading traffic tickets for potato chips, so to speak.
I love it.
And again, another lesson learned.
Hey, valuable potato chips.
I am apparently so, but it was one of those things that we spent a couple of months in trial, and the government lost that case. And there were perhaps many reasons for that, but there were also a number of convictions that came out of that. At the Recorder's Court level, there was one judge who was trading felonies for money, and that's a much more serious issue. So overall, I view that as a success for the government back then. So we did secure a number of convictions because, again, of anyone who holds public office and does the public business, the one person that should be above any kind of concern should be a judge.
Absolutely.
Should be you have to trust the system for the system to work. And so I think that was an important work for the office back then.
Absolutely. When you're trusting a judge to make a decision, many cases about your life, you want that judge to be on the up and up.
You want an objective, fair, thoughtful. Even if you lose, you want to believe at least you were treated fairly and
justice
honestly.
was served.
Yes.
Absolutely. Absolutely. There's a quote here about you, and I'm gonna read this. It says, "Mr. Gershel has a focused vision for the future, decades of experience successfully managing a team of attorneys, and a reputation for professional integrity that will be a credit to the AGC." And that was stated by Michigan Supreme Court Chief Justice Robert Young, who actually appointed you to
Correct.
the AGC, and I think he was really on point. I believe integrity is one of the most important qualities to have. And not only did he see that in you, but you were also awarded the Integrity in Our Communities award by Cooley Law School.
Yes.
So obviously, and you know all the jokes about lawyers and the whole 9 yards. So this is really golden to find an individual who has had such a stellar career and who has maintained that sense of integrity. As the Attorney Grievance Commissioner, you were appointed back, I believe,
Past October of 2014. Correct.
And there was some issues there in regards to the commission and some drama. But you went into that position. How has your experience been from October to now, and how have you moved forward?
It has been terrific. It's a great office comprised of great people who are committed to the work and the mission of the office. And I have found it to be a very satisfying, positive, and it's been a great learning experience for me as well. I mean, change is certainly hard for the staff and for me, but I've been there about 9-10 months, and I think that we're going very much in the right direction.
Great. When you first took office, what was your primary focus in regards to the Attorney Grievance Committee? What changes did you want to make? What did you feel was vital to address your first month?
I think that someone who comes into a situation that they've not been in before, and I did come into it, in a way it was a difficult situation. I had no prior experience really with the office. I didn't know very much.
Well, you sat on the board.
I was one of the hearing panel. I sat on the hearing panel.
For the commission.
So I got to meet over the 20 years that I served as a panelist, some of the attorneys in the office, but we would hear cases maybe once a year. So I didn't have a lot of contact with it, and I felt that it was most important for me coming into that situation to take my time, to really get to know everybody in the office and to not rush to make changes for change's sake. And I thought that a manager should just get to know the office, get to know the culture, get to know the people, get to know how people, how they get along with each other. So I was on a learning curve too, and they, they didn't really know me, and I didn't really know them, and so I took my time before I wanted to make any real changes. But I'm sorry.
No, absolutely. I do sense that there is a focus, a returned focus, and I believe that your changes or your presence there has created that sense of let's get this done and let's work together, and that camaraderie is definitely strong. Explain to us exactly, and our audience, the Attorney Grievance Commission, what its role is, and how it affects us as citizens.
Fundamentally, the role of the Attorney Grievance Commission is to protect the public. And this is, in essence, can be another form of prosecution. In other words, attorneys are expected to comply with the rules of professional responsibility. And
so they're held accountable.
They are held accountable. And what happens if a client, for example, feels that he or she has not been treated appropriately by their lawyer, there is a process that they can file a complaint with the Attorney Grievance Commission. We have a web page. The form is online, and an individual is encouraged to file their complaint. Every complaint filed by anyone is looked at by a senior attorney in the office. And last year, we had approximately 3,000 complaints. So we get a lot of complaints. But everyone is looked at. Of course, some are serious, some are not so serious. But everyone gets looked at. Everyone who files a complaint will get an answer from the office. And those cases that are deemed to be some merit will be assigned out to staff counsel for an investigation. And the way the process is set up, if you want me to describe that for you,
sure,
is that there is a grievance commission, and I work with the commission. So if in fact we decide we have a case, we've looked at a case, and we have certain recommendations on a case, we present that case to the commission. The commission is composed of 9 individuals that are appointed by the court. Some are lawyers, some are not, and we meet every month, and we make recommendations to the commission as to what we want to do on a particular case, whether it's to file formal charges, and they would review that and approve that, hopefully most of the time. And then that really begins the formal side of the office. So really the gamut of discipline can run everywhere from really closing the case all the way up to filing formal charges and seeking disbarment. And the conduct of lawyers, I mean, lawyers are people, and they get into can get into trouble just like over potato chips. And sometimes the conduct is just an attorney who may be overworked and not really minding the store the way he or she should. In other situations are much more serious, where attorneys are actually can be taking money and property from their clients. So it's the whole gamut. We have a staff of 13 lawyers. We have an investigative unit that will do the, and we have, of course, a very large administrative side of the office as well. We're an office of about 35 people right now, and I would encourage any of your listeners, if they have had an experience with a lawyer that they believe is something that causes concern, they should file a complaint, and we will take a look at it.
So basically, you receive around 3,000 to 4,000 complaints.
It was over 3,000 last year.
And I think I understood that only 8 to 10% of these complaints actually, is that correct?
Well,
actually go into the disciplinary process?
There is, along the way, the road of discipline, so to speak, there are various steps that we can take. If, for example, we can close a case with caution, which would be a non-public form of discipline. Let's assume an attorney has done something that is not terribly serious, but we tell the attorney, we're closing the case, but be advised of the following. And that's not public discipline. If an attorney, for example, and this happens unfortunately, gets involved in misconduct with the law, whether it be driving while drinking, using drugs, we'll prosecute those cases. And sometimes it's a situation where we'll put the person on what's called conditional probation, which again is non-public, and the condition of that probation would be to get help. There is an organization with a state bar called Lawyers Judges Assistance Program, where we direct these individuals, and hopefully, you know, we want them to get well. Every case that we have, we don't want to prosecute. If we can help someone, and educate someone, that's part of our mission also. And then again, as the discipline severity increases, the discipline will get ratcheted up. A next level might be what's called an admonishment. Again, that
sounds serious.
It is, but it's not public. It's not, for example, the public is unaware of that. It's a situation where an attorney maybe is engaged in some misconduct, might have done it before, and we admonish them. And then if it continues, then the next step would be the filing of formal charges, which we call a complaint. And that's public. That's public, and the public can and come to those hearings and see what goes on. And that's really, at that point in time, it shifted over to the Attorney Discipline Board. And they have a number of panels comprised of volunteer lawyers who will hear this case and decide what the appropriate resolution should be. So about 8 to 10% result in formal charges, but a number of cases are resolved in just the way I've just described for you.
So the confidentiality factor, I mean, you do have a large staff.
We do.
So how does that play into, because obviously when lawyers, I mean, I'm sure you see, out of 3,000, some of these are very petty kind of things, and obviously not all this is public, but where do you draw the line in terms of the confidentiality issue? Or if there's a lawyer who has, many complaints and has not gotten to that level of, discipline, but yet, there's a number of complaints there. How do you deal with something like that?
One of the important factors for the office and for me in deciding what's the appropriate resolution of a case is, of course, their prior conduct.
Right.
It's relevant when I was a prosecutor at the U.S. Attorney's Office. It's relevant to our determination now, because obviously if this is a first-time offense and it's not terribly serious, the public hasn't been harmed, or the client hasn't been harmed, we'll try and resolve this case in a favorable way. If, in fact, there's a history of this, it's the second or third time of similar kind of conduct, well, that sort of suggests a situation where
A red flag?
it's a red flag, and a more aggressive response has to be taken by the office. Because again, at the end of the day, the function of this office is to protect the public. And again, you're correct. A lot of the grievances are, while they may be important to the client, certainly who files a grievance.
Didn't call me back.
Well, and we laugh about that, but interestingly enough, we get a lot of that. Didn't call me back. Was rude to me, was disrespectful, charged me too much money. So a lot of those things, which again, I'm not minimizing the importance to the client.
Those aren't legal issues.
But those aren't ordinarily the kinds of issues that we will take any kind of serious action against a lawyer for.
What has been the most serious complaint you've gotten from a lawyer? From a client about a lawyer?
We've had cases, for example, where the attorney is serving perhaps as a trustee or a conservator of the client's estate. The client may be ill, either physically or mentally, and the lawyer's taken property from the client. Now that's serious. That's very serious. The misappropriation of money or property from a client is on the scale of 1 to 10. That's up there, because that really is serious misconduct.
Isn't that something with the T-A-O-N? Is that?
Yeah, okay. Taon. We get a lot of that. Generally speaking, attorneys have to, for example, maintain what's called a trust account.
That's if the client doesn't have anybody to maintain that.
Well, if a client, for example, pays an attorney money as part of the representation, ordinarily that money must go into the trust account. An attorney must set up a trust account, and as fees are earned in connection with that representation, the attorney can take that money out. But there are very specific rules that an attorney must follow managing his or her trust account, and so we get a lot of that. For example, the way the law has been set up, the bank will notify us if an attorney is trying to cash a check with insufficient funds in the trust account. That's sort of a warning bell. And so when that happens, we will reach out and contact the lawyer. We have a senior attorney on staff who's devoted to these, looking at these cases. And sometimes it can be something as simple as a solo practitioner trying to manage a lot of cases and gets a little bit sloppy, or says to someone not fully trained, handle my trust account, to something more serious where the attorney is perhaps putting his money in with the trust account with client's money, or taking out money that he shouldn't be taking out. So again, even that kind of conduct runs the gamut from perhaps negligent inattentiveness to serious intentional misconduct. But we get a lot of those cases also. Absolutely,
absolutely. You don't have, if someone came in with a complaint regarding a law firm and an individual from that law firm, now would it be just the individual that you would have jurisdiction over, or would it be the law firm itself?
Not the firm, just the
individual. So they wouldn't be liable.
It could be several attorneys in the firm but our investigation, and if there's any kind of follow-up action, it's directed at the individuals, not the firm as an entity.
Okay. And in terms of judges, that's not the Attorney Grievance Commission?
No, there is a separate, that's the Judicial Tenure Commission,
right.
and they have jurisdiction over judicial misconduct. But we work with them. So, for example, if Judge X has committed misconduct in connection with his official duties, and a decision was made that this judge should be taken off the bench, we can then look at that conduct because they're no longer a judge and they may have violated rules. So we can also,
it goes back to your
they
office.
can come back to us too. So that sometimes happens, actually.
Amazing, amazing. Well, you definitely have a rich knowledge of everything that we've just discussed, and it's a half-hour show because we can talk about this forever. But you've just written a book as well, and this is an amazing book, which is a law book, and it's being used in
Yes.
classrooms.
Yes.
It's called Criminal Law Cases, Statutes, and Problems. Problems is the key word
Yes.
there. And so it was written by Corbett Bretz and, of course, Mr. Alan Gershel. So really quickly, I think we've got a couple more minutes. Okay. Tell us about your inspiration in writing this book. And I was looking through it, and I mean, it's just from domestic violence to rape incidents to the whole, 9 yards in regards to the law. But what was your inspiration in writing this, and what law students or classes would be using this book?
Well, when I left the U.S. Attorney's Office back in 2008, I went to teach at Cooley Law School, now Western Michigan University Cooley Law School, and because of my background, I taught criminal law and related classes. And over some time, it became apparent to some of us it'd be nice to write a textbook that was really practical in approach, that was filled with practical problems. I mean, a lot of law books tend to be somewhat esoteric with lots of footnotes. And we decided
I thought they were really interesting.
Well, and so we tried to write a book that would capture the important cases for that topic. And then within each chapter, we tried to create a series of practical problems that a student and a lawyer might face. And so that was our goal, and hopefully we've accomplished that.
You have. You had my interest. Okay. I was actually reading this, and I'm thinking, okay, well, let me just skim through it. And I actually read some of the scenarios and really captivated my interest.
That was our goal, to try and do that. So
absolutely.
Hopefully we've succeeded.
Well, you've encouraged me to take a law class with this book. Anyway, very, very, very well done, and the students that are using this book are very fortunate. Because, I mean, obviously law books are not the most entertaining books to read, but this was very captivating.
Thank you.
I want to thank you so much for being here.
Thank you for inviting me.
I think the information that was shared is absolutely invaluable, and the Attorney Grievance Commission can't be in better hands.
Appreciate that.
Thank
you so much for having me.
Thank you very much. Mr. Alan Gershel, the Attorney Grievance Commissioner for the state of Michigan. Thank him very much for being here, and thank you for joining us on Community Connection. We'll see you next time.